ADA is also known as the Americans with Disabilities Act, and it certainly is a federal civil rights law that protects against discrimination against people with disabilities in the workplace and in their daily life. So that is an important civil rights law that everyone with a disability should know about. And certainly under Title I of the ADA law is really important for employment.
The Americans with Disabilities Act applies to employers that have 15 or more employees. Many states have similar laws that mirror the ADA, but apply to employers. With the prior interpretations of the Americans with Disabilities Act, many types of impairments were found not to be covered under the Americans with Disabilities Act. So this would include impairments that would go into remission or were episodic, such as with MS, or impairments that could be corrected by mitigating factors such as medication or devices. And with the Americans with Disabilities Amendments Act, it provides that even illnesses or impairments that are episodic are covered under the law, and that mitigating factors will not be taken into consideration with the exception of eyeglasses. In the Amendments Act, the Act actually lists a number of conditions that are considered to be impairments, and this includes MS, so that there no longer will have to be a determination of whether somebody with MS is covered under the law. The changes mean is that the focus will now be on the employer policies and the employer behavior and whether or not the employer has met their obligations under the law, rather than whether or not a particular illness or disability falls into the meaning of the ADA.
The most common issues that people run against, I think, is whether or not to disclose whether or not you have a disability. And it's a very personal choice. There's nothing that's scientific about it. Certainly, if you are asking your employer for an accommodation, you do need to disclose. That's a very, very big issue for people, and it's a very personal issue. I think people also need to be educated about the laws about the American Disability Act so that you can really be also very proactive in what it is that you want to ask for and what your rights are.
The ADA has 3 tiers of requirements regarding disclosure. The first is the pre-employment phase, while somebody is interviewing for a job or making inquiry about a job. And during this phase, no medical questions are allowed. A prospective employer cannot ask an employee who's interviewing about whether or not they have a disability. They can certainly ask whether or not somebody can perform certain essential functions of the job, but the focus can't be on the disability that the employer either perceives that they have. Once somebody's offered a job, if it's a conditional job offer, it can require that the employee provide medical information or even undergo medical testing. The important thing to remember is that people can't be singled out by the employer. It has to be a policy that's applied to everybody coming into this level of employment. But it's important to remember that if even during this medical inquiry phase, somebody discloses that they have MS, the employer can't renege on the job offer unless they can establish that as a result of their disability, they're not able to perform the essential functions of the job. Once somebody's actually working, then an employer can only request medical information if it's consistent with business necessity. But if an employer senses that somebody is struggling in their job or perhaps posing a threat to themselves or others in jobs that might involve public safety, then the employer has the right to request medical information. If an employee requests a reasonable accommodation, they are required to present medical information that supports the fact that they are a person that's covered under the law. Under the ADA, an employee has the right to request a reasonable accommodation, and this is something that an alteration in their work schedule or something that might help them to do their job better. What's important to remember is that the law requires what's called an interactive process. so that when somebody requests an accommodation, the employer generally can't say no. They can say, this might not work for me. Let's talk about what's going to work for both of us. But the only time that an employer has the right to say no is if the accommodation request would be an undue burden, and that's a very difficult burden for the employer to meet. So it's important to remember that it's the employee who must come forward and say, you know what, I can perform my job, but I do need an accommodation. I think the first thing somebody should do if they feel that their rights are being violated is, if there is an Office of Human Resources, talk to them. Oftentimes, supervisors don't understand how the law works or what the employer's responsibilities are. HR does. A person could file a complaint with the EEOC if it's a violation of the Americans with Disabilities Act, or with the Office of Civil Rights, OCR, if it's a violation of the Rehabilitation Act. I always suggest, if somebody feels that they're being discriminated against, that they also talk to an attorney, because it's important to understand your state laws as well.